Welcome to the second show this week of Questions for Lawyers. This, believe it or not, is our 18th show, I'm proud to say. My name is Jeff Edelman. I'm a personal injury attorney. And what we try to do on this show is I bring on different attorneys that I know in different specialties, and I ask them about their practices and ask them about who needs the type of services that they perform. Now, I know that sometimes people have an anxiety about hiring an attorney. We're trying to take some of that away. So it is my pleasure to welcome to Questions for Lawyers my good pal, Bobby Beraha from Berger Singerman. Thanks for coming on, Bobby.
Thanks for having me.
Well, if you could, can you please tell the audience a little bit about your background?
Sure. I'm an attorney. I've been out since 2004. My specialization is in trust and estates. That's all I've focused on since I started practicing law. I have an LLM from the University of Miami. And right now I'm practicing at Berger Singerman and focusing on really the whole, tax realm related to trust and estates. I draft wills, trusts, buy-sell agreements, do a lot of planning for closely held businesses, probate and trust administration, really the entire realm of estate planning.
So you went to Florida and Miami. That's what you're saying?
Yes.
And so they're playing each other, I believe, in August, September. Where's your allegiance on that?
I've always been loyal to the Canes, so I'm gonna stick with that. Although it's very tough. I was hoping that they wouldn't start playing each other regularly, but now it looks like that's going to happen. So,
well, the Nova Southeastern Knights don't have a football team, so I think I'm safe for now. But who knows? In 5 years, things happen.
You never know.
Well, I want to talk to you about a few of the areas that you practice in, Bobby, and one of them is asset allocation. Now, sometimes people call asset allocation asset protection.
Mm-hmm.
What is asset allocation, asset protection? If you could.
Well, I wanted to clarify. I mean, asset allocation, asset protection, they are synonymous. Asset protection kind of has a negative connotation because it conjures up images of people, stashing assets offshore, to hinder, delay, or defraud their creditors. But, actually it's just titling your assets in a manner where they, are protected from creditors that, ordinary people would run into, because sometimes, people become liable for things that aren't necessarily their fault. And, you want to make sure that if one of these unfortunate events happens, that things are titled in such a way where they're not low-hanging fruit for your creditors.
Let me ask you this. Now, for anybody who is watching, what are some basic things they can do to protect their assets without even going to a lawyer?
Well, the easiest form of asset protection is for a married couple having your assets titled as tenants by the entireties, which is the default tenancy for married couples in Florida. That way, the creditors will only be able to attach the assets of both husband and wife, and the creditors of just one of the spouses would be exempt. So it'd have to be creditors of both spouses to be able to attach jointly held assets. And Florida has, Florida is a very debtor-friendly state, as I'm sure everybody knows. Mm-hmm. And so, your best protected asset, obviously, is your homestead. It's unlimited in value in terms of what's protected. It's 160 acres outside a municipality, half an acre inside a municipality, and creditors, other than super creditors such as the IRS, cannot touch it.
Well, it's interesting that you say that as many people know, sometimes I get into situations with auto accident cases where there's not enough insurance money, and the client says, well, I want to go after their assets. Well, Florida's not the best state for that, is it?
No, definitely not.
And that's
Definitely
the reason why, because if you own a property, if you own your home and you homestead it, you're not being forced to sell your home.
Right. Your equity is totally protected.
Exactly.
So,
So that's something that I frequently get, and I have to explain that. What I usually do is I say, there's a reason why O.J. Simpson moved to Kendall around the time of that murder trial. And
right.
It wasn't because of the wonderful weather in Florida.
Right. It's a very, very common move is to go buy a nice big homestead in Florida as a creditor protection move.
All right. Can you talk a little bit about your estate planning practice?
Sure. So my practice is really, comprised of, like I said, I draft wills, trusts, estates. I do closely held business planning. I just, really the, entire realm having to deal with estate planning. I represent clients, really of all walks of life. Anywhere from the most simple engagements all the way up to, the high net worth planning, the more complex things. So
who needs estate planning, Bobby?
Really everybody. I mean, whether you're worth $100 or $100 million, everybody has issues. We're all going to die. We all, through some unfortunate incident could become incapacitated. So you want to make sure that in the event something like that happens, that there's a succession plan in place. And, it can all be done in a way where not only are you hitting the goals of providing a succession plan for your family, but also you are protecting your assets from creditors and additionally keeping those assets out of court, and I'm talking about probate or guardianship, or additionally keeping those assets out of the taxable estates of your, spouses and descendants going forward. So, really everybody has, whether it's tax exposure or just making sure that you're protecting your beneficiaries both from themselves in terms of putting barriers in place. If you have a child with issues where you don't want to cut them loose with, a bunch of money at too young an age, or you want to, just make sure your assets, pass if you get married and then divorce and your spouse remarries to have some control, when you're gone in terms of the flow of those assets. That kind of all goes into estate planning, making sure that you have some control and you're passing your assets on in the most tax efficient way and the most protected way, they can possibly be passed on.
So what we were talking about before with the asset allocation, asset protection, whatever you want to call it, and the estate planning, they really go hand in hand, right?
Right.
Okay.
Right. There's always, if you take a holistic approach, you can kind of accomplish all the goals just by setting, these plans in motion. And then once you have it in place, you can kind of rest easy that, that your affairs are squared away in the event the unthinkable happens.
Nobody wants to face the facts that we are all going to leave this earth at some point. And I think that a lot of people put off their estate planning and put it off, don't want to think about death.
Right.
What happens if you don't have a will?
So if you don't have a will, your assets will pass via the laws of intestacy, which basically means that the Florida statutes and the courts will dictate where your assets will go if you die. Whereas, if you have something as simple as a will, at least there's a directive that you participated in creating that will, dictate where those assets will go, who your fiduciaries will be. And, not having a will and having all of your assets be subject to probate, which is what happens when you die with assets in your individual name, basically forces your heirs to hire an attorney like myself or somebody else to go into probate court, administer your estate. And I mean, in South Florida, where we practice, even under ideal circumstances, that can take up to 2 years. That's with no creditor issues, no nothing. It's just, that's how long it takes. And it's very expensive. And it's ultimately very avoidable.
How can somebody avoid probate?
The way you avoid probate is by setting up a revocable trust. So a revocable trust is essentially a will substitute, but you can title assets in a revocable trust during your lifetime. So it's a separate legal entity that the creator still continues to control during their lifetime. It's for their benefit. But then if they become incapacitated or upon their death, the assets continue on pursuant to their directives in the revocable trust, and it continues on seamlessly rather than having to have those assets go through probate and through the whole process, that takes 2 years before it ultimately goes to their beneficiaries.
So that is the way to avoid probate. And while it may be more expensive than putting together a simple will, it actually benefits the estate by doing that. Is that what you're saying?
Right. Your estate will save money in the long run by doing the planning up front, as opposed to having to deal with the probate administration that's costly and lengthy when you're already gone, and have everybody trying to guess what your intent may have been if there's any, if there is any contest issues.
Let's say somebody hires a attorney such as yourself, and they do this paperwork.
Mm-hmm.
And 30 years later, the person passes away. Mm-hmm. Is there any expiration on these papers?
Well, depending, on each person's individual circumstances, we usually try to, each client of ours, if there's any changes in the tax laws that, would impact somebody's plan, we try to keep them, abreast of that. Mm-hmm. But, beyond the tax issues, which none of us have any control over, it's kind of all...
They're kind of changing on the fly right now.
Right.
Aren't they?
It's kind of like trying to, estate plan in quicksand. Mm-hmm. I know what the law is now, and I know what I think is going to happen, but nobody knows. It changed dramatically under Trump. It could change dramatically, for whoever follows up Trump. Mm-hmm. If everybody runs to the other side of the boat, we could be in a totally different planning environment in a few years. But so is staying on top of the law, and then ultimately staying on top of if you have a drastic change in your life circumstances, mm-hmm. Divorce or a change up or down in the value of your estate, mm-hmm. Obviously you're going to want to revisit your planning documents. But in terms of what you put into place, there's really it's not going to just naturally expire on its own terms. It's really just keeping up with the applicable law, and then, making sure it still reflects your intent given, your most recent circumstances.
If circumstances do change, however, those circumstances can be taken into account even with a 30-year-old document.
Right.
It's not like all of a sudden crumple it up, throw it away. It's like, okay, well, we have to make some adjustments.
Right. You everything is can be modified. There are irrevocable trusts, and if you use those, you can be somewhat limited in the changes you can make. But ultimately, when it comes down to the core estate planning documents, we can adjust them as needed, to reflect the changes in circumstances.
Now, along with a revocable trust, a will, are there other documents that you also recommend for clients if they're already making those type of decisions about their estate?
Yeah. So the basic package, so to speak, the kind of basic estate plan that everybody mm-hmm. should have is comprised of, like we already talked about, the revocable trust, but also, even though you have a revocable trust, you're still going to have what's called a pour over will. And a pour over will, is just that. Anything that's titled in your individual name that happens to get missed, that isn't titled into the name of the revocable trust, the will says that anything in my name upon my death should be poured over into the trust. So everything ultimately ends up in the trust. So revocable trust, pour over will. Then there's a durable power of attorney, which is the document that, if you become incapacitated, would allow whomever you designate to, deal with your day-to-day affairs in your shoes while you're unable to do it yourself. Your financial affairs.
Right.
Deal with, accounts that you have in your name, like with utility companies, deal with insurance companies, all those things that you would, kind of need to get in line, if in the event of your death. And then there's the healthcare documents, which is the living will, which is, persistent vegetative state, no meaningful hope for recovery.
Two doctors.
Whomever you designate has the authority to authorize the doctors to withdraw life support. It's the pull the plug document, so to speak.
That's became famous with the Terry Schiavo situation here in Florida.
A short 3-page document could have saved a lot of
litigation,
of agony and litigation,
no doubt.
So the living will, and then there's the designation of healthcare surrogate, which is also a healthcare document that controls all the decisions short of the ultimate pulling of the plug decision. Consult with doctors, day-to-day treatment decisions, and so forth, to the extent you can't make it yourself.
And to a certain extent, some of those issues are more important than any money. I mean, having somebody designating a person to make medical decisions when you can't voice them yourself, I mean, that's essential. I mean, there's nothing more important than that.
Absolutely.
So now let me ask you this. We were talking a little bit about asset allocation. We're talking about estate planning. And what I want to ask you about is life insurance. Is life insurance, do those proceeds pass through the estate?
Well, they're not part of the probate estate.
Right.
Any assets that have a beneficiary designation, such as life insurance, will pass automatically to the beneficiary outside of the probate estate.
Right.
So, that's one of those assets that are typically excluded from probate unless the person, and we see it, all the time, don't name a beneficiary. So then it becomes an item in limbo and, may be pulled into the probate.
So make sure you have a beneficiary and you have an alternate beneficiary.
Right. Make sure you have a beneficiary designation that's current and reflects somebody who's alive.
Now, Bobby, I'm sure that you've gotten these calls before where people are either on their deathbed or in bad shape and they don't have these papers together. They're of sound mind and they're able to make decisions. Do you sometimes have to go and visit people at their homes or hospitals or anything like that?
Yeah, I mean, to the extent that's necessary, I've certainly done that before. Okay. Never an ideal, circumstance. I mean, the person has to be, coherent and aware of, their estate and of, how the assets are going to pass. They have to be competent enough and with it to be able to have, to be able to form the requisite intent to be able to create these documents.
Right.
And be able to sign. So, while I do the hospital visits, sometimes it becomes difficult to get somebody who's in really bad shape, to be able to acknowledge, what they're trying to do. And I mean, sometimes it's just impossible. But if the person is aware and lucid and I can do anything to facilitate, those types of transfers, then, or, putting together documents for a person who's in that condition, I'll certainly do what I can.
And you or your staff are notaries as well, so
Right.
you can actually have those documents signed.
Right. You need two disinterested witnesses and a notary in order to execute these documents validly.
But you really want to avoid doing a hospital bed will or anything like that. The time to do it is when you're healthy, right?
Right. Healthy, of clear mind, and when you typically, by the time you get into that in that position, something is going to get left out, or you're not going to have time to retitle assets in a way where the plan will achieve the most benefit. And it is ideal to get everything done while you're healthy, or at least healthy enough to come into the office.
Well, Bobby, I really appreciate you coming and driving up here from Miami to speak with me. Do you have any last minute advice for anybody listening now or maybe later about things that they can do to protect themselves? I know we talked about homestead, but are there some other vehicles that are available to people that they can know are protected from creditors?
Mm-hmm. Yeah. So, for instance, if somebody owns a lot of real property, and in Florida, a lot of people own, rental properties at the beach that they, hold out for rental. And, whenever there's renters, there's always concerns about, premises liability. What you can do is, instead of owning that property in your individual name or even in your joint name, with your spouse, the best thing to do to insulate any liability resulting from that property from creditors, resulting from premises liability, is to put that property in its own separate LLC. That way, if somebody does, in your lexicon, slip and fall on the property, and there is a judgment, the only thing that would be vulnerable to attachment by that creditor would be the equity in that property.
No matter how hard I try.
No matter how hard you try.
Well, that's important to know. What about like IRAs?
Qualified plan assets are statutorily exempt from creditors.
So it's important to put money away.
Right. That's a good thing. So your equity in your home, qualified plan assets, the cash value of life insurance, all those things are statutorily protected from creditors in Florida.
Now, Bobby, your office at Berger Singerman is a pretty large firm, and you have your office down in Miami. Where else does Berger Singerman have offices?
They have offices in Fort Lauderdale, Boca Raton, and Tallahassee.
And you're available to meet in those offices?
Yes.
Okay.
Absolutely.
Can you, and if anybody would like to speak with Bobby about estate planning or asset allocation, his office number is 305-755-9500. That's 305-755-9500. Bobby, if there's I certainly appreciate you being on. And if there's anything else you'd like to say about your firm or about your practice, I want to give you that opportunity now.
Okay. It's really just, I know it's an unpleasant thing to reflect on your mortality and to think about, issues and what happens if upon your death. But, it's really, essential to kind of stop and talk about your family, think about your family and talk about these things with them, and come in and, and get an estate plan done, or at least, come in and have a consultation to make sure, everything's titled in such a way where they're protected from taxes and creditors and the probate process as much as possible. And it's a real peace of mind to get that done.
Bobby, thanks so much, man.
Thank you.
So good seeing you. We'll be back next week on June 6th at 10 a.m. I will have John McMenamin on who is a homeowner's insurance attorney. He handles property damage claims, hurricane claims, and with hurricane season right around the corner, it's a pretty timely guest to have on. Hopefully, we won't be needing him, but he will give you some advice about different things you can do to protect yourself during hurricane season and how to file a claim. Heaven forbid that we need to do that. So I'm looking forward to that. Thank you, everybody, for watching, listening, and we'll see you next week. Enjoy your weekend.